Hi everyone, Kim Keat here and you are watching OK Law. So actually we took quite a long time to build up, but today we are finally focusing on the actual trial of a criminal case.
Hey, Kim Keat, where's my intro?
But people already know who you are. What?
No, they don't.
Have lah.
Where's the evidence for that?
Oh, asking for evidence ah. Just nice. Okay, Simon, so actually I got some questions for you on what kind of evidence we can bring inside the trial.
Yes, but before we go there, so my name is
Yeah, the
Simon.
evidence, right, is actually very, very important. It can make or break the case. Correct, right?
Yes, Kim Keat, you are right.
So actually, right, like, cannot be that both sides of a case can just anyhow bring in all kinds of weird evidence to support their claims. Cannot be they say, oh, my ah gong said that, then my ama said that, then my auntie called me 帅哥 the other day, that means I'm very handsome.
Stop it. Get some help.
I'm pretty sure the Cai Peng auntie did not call you 帅哥. But in any
Got lah,
case,
you never hear.
yeah, I don't want to hear that. So maybe that might have occurred, but the important point is that there are some restrictions on the evidence that you can bring before the court. But before we go there, I think it's appropriate for us to cover the concept of burden of proof. So the burden of proof basically describes whose responsibility it is to produce evidence to back up a claim that they are making.
Okay, so who is going to be bearing this burden?
Yep, so the person that bears the burden is basically the one that's alleging a claim, and so he has the responsibility or the burden of proof to bring out evidence to support this claim of his.
Okay, so for example, in a criminal case, right, the prosecution is claiming that the accused person has committed a crime. So it's actually the prosecution who has the burden of proving that the accused person is guilty.
Yep, that's correct.
Actually, I have another question. Let's say I say that I'm claiming that this or that thing is true. So how much must I prove before I'm considered to have proved it? How much evidence must I come up with? Is it that the side with more evidence will win?
Though not necessarily. In fact, quality over quantity is something that we would consider in terms of the evidence that's adduced.
Quality, huh? So is there some kind of scale that you use to measure the quality?
So we don't really have scales, but there is something called the standard of proof, which is the level of proof that is required in order for you to have met this burden.
Standards of proof. So let's talking about standards already. So a criminal case quite serious, huh? Yep. So I will assume there would be quite a high standard to meet.
Yes, because of the penalties imposed by criminal cases, the standard is higher than that of a normal civil case, and we call this criminal standard beyond a reasonable doubt. So proving something beyond a reasonable doubt. Okay,
so my next question is, if the accused person, right, can come up with some kind of reasonable doubt to doubt that he is the one accused or guilty of committing the crime, then that means that he will win?
Yeah, so not that he would win, but it would mean that the prosecution has failed to prove their case beyond reasonable doubt. So basically it means that the prosecution did not meet the standard of proof that was required of them.
Okay, so let's talk about the actual evidence you can bring into a trial. So actually we can see this on a lot of TV shows, right? Both sides will bring in their own witnesses who will support their cases. Then some more, you can dig up documents and you can then bring it to the court and show it as evidence also, correct?
Yeah, I see you have been watching a lot of Suits. So you're right, these are the two main types of evidence. We have witnesses and we have documentary evidence.
Okay, so actually my big question is this. What happens if, let's say, one side decides to try and bluff the judge, comes and makes up some kind of evidence? So for example, I go and pay somebody to come to court and say that I saw Jerry stealing potato chips from 7-Eleven. So, how?
That's a good question, and maybe at this stage we can look at how the court admits evidence. So there are generally three main stages to how the court would handle evidence. The first stage is admitting evidence. At this stage, there are several gatekeeping rules where only certain types of evidence will make it true. And if your evidence doesn't pass through these gates, then you cannot bring your evidence into the trial.
Wow, okay, so there's gatekeeping. Okay, can you tell me more a bit about the types of evidence that cannot make it?
Sure. So without going into too much technicalities, one of the ways in which the court would not admit evidence one of the grounds rather than which the court would not admit evidence is if it deems it to be unreliable because the evidence is probably easy to fabricate.
Oh, okay. So if it's like he said that she said that Abing said that his Amma said that her WhatsApp chat said that this and that happened, then cannot lah.
Yeah, so whatever you said is basically what we call the hearsay rule, and we do not admit such evidence because, as you can probably infer, it is easy to fabricate such things.
Okay, so moving on, let's talk about the evidence that actually makes it past the gatekeeping. Could you explain a bit more about that?
So this will go into the second stage of weighing the evidence. At this stage, the judge decides how much importance to place on the evidence that has been admitted. If the judge deems it to be very low quality, then he will probably not take it seriously and give it very little weight.
Oh, low quality like a 144p YouTube video?
Yes, so it just means that technically some of the evidence that has been admitted past the first gate will be given a very low weight if the judge doesn't think it is reliable. But you must understand that the two stages exist, so the admitting of evidence and the placing of the weight exist for the same purpose, which is to determine the reliability of the evidence.
Okay, so tell me more about the last stage.
So the last stage, or the last way in which evidence is evaluated, is when the judge excludes evidence. So this is a reserve power that allows a judge to cut out evidence that gets admitted through the gatekeeping rules, as long as it is in the interest of justice to do so.
Oh, okay, I see. So I guess you would really want to gatekeep most of the lousy evidence in the first two stages, right? So this last stage should be for really exceptional stuff that falls through the cracks, correct?
Yep, pretty much.
Okay, bro, so let's start talking about witnesses. Right? So actually here's my big question. So both sides can call in witnesses to support their cases, but then what happens, right, if those witnesses on both sides say completely different things? So for example, Jerry brings in a doctor, then the doctor says, oh yeah, he was sick. But then the other side also brings in a doctor, then a doctor says, this fellow is talking. Then who to believe?
That's a good question. So in such a situation where you are dealing with witnesses, there are actually other gatekeeping rules that apply. And in this specific example that you brought up, where we are dealing with doctors, we will call this set of rules expert witness rules or gatekeeping rules. And that's because judges are not experts in the field of medicine or of engineering, they are legal experts in the field of law. So the purpose of getting these expert witnesses in, for example, doctors or engineers, is to explain these more technical concepts to the court to assist them to get a clearer picture of the facts.
Okay. But not everything you need experts for, right?
Nope, not everything.
So let's say I see somebody getting robbed, then I'm the witness. I don't have to be the expert on robbing people, right?
Nope, you do not have to be.
Wait, but then the robber is the expert on robbing people.
No. That's not how it works.
Okay, so moving on. Just now you mentioned that when there are witnesses, then there's other gatekeeping methods, right? So what are these other methods?
Yep. So one of the gatekeeping methods that we have to ensure that a witness's testimony is reliable is that of cross-examination.
Okay,
so,
cross-examination.
Yeah, so cross-examination works when the witness is put on the stand and the lawyer examines his testimony in front of the judge.
Okay, so after all the evidence is presented, right, then the judge will look at everything and will come to a decision.
Yep, that's correct.
Okay, so time for another roundup of everything we've talked about today, which is quite a lot, right? So first up is the burden of proof. So in a criminal case, the prosecution has the burden of proving that the accused person is guilty. Then after that, we have this thing called the standard of proof. And in a criminal case, there's a very high standard. The prosecution has to prove to the standard of beyond a reasonable doubt. So okay, after that, we come to the kinds of evidence that you can bring into the trial. So actually there's 3 stages to letting evidence go into the trial. Number 1 is admitting evidence. So at this stage, there's all kinds of gatekeeping rules, especially those kinds of rules that are trying to cut away all the unreliable evidence that can be easily made up. Second stage is weighing up the evidence. So at this stage, the judge will take a look and see whether he thinks the evidence is very important. And then in the last stage, that's excluding evidence. This one is a reserve power. It's actually only used in very exceptional cases where the judge will exclude evidence if it is in the interest of justice to do so. Next, we have the witnesses. So both sides will also produce witnesses in court, and both sides' witnesses will be cross-examined by the lawyers. This is so that the lawyers can get at the truth. and also will sometimes show whether the witnesses are reliable and trustworthy. Then after everything, right, the judge will look at all the lawyers' arguments and evidence from top to bottom, and they will make a final decision. 10 out of 10, right?
10 out of 10. Good job.
So that's all for today, and see you guys next time.